Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is, then you are applying 3 without the proviso and saying this is a blanket power, then then Malaj, the president can do it anytime without any consultation.
Also, Mr. Sibal, one thing which we must
just passes an order
Mr.
that I
Sibal,
integrate.
Yes.
That's
which is very different from what is subject matter of 1 and 2,
yes, right.
because they do not deal with abrogation of the
Absolutely,
article.
absolutely.
right.
Yes, absolutely. Your worship is right.
And therefore, when we read at that power, which is specifically conferred on the president,
Yes.
then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No, I
For the time being, just leave the proviso.
Well, I can't read the Constitution in this fashion. I can't even read an act in that fashion. Let's forget the Constitution. How do I leave the proviso when the Constitution is staring us in the face?
No. The question
Your
was,
notice is putting to me.
therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct. But it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso is satisfied, that clause 3 will apply. Otherwise, if the conditions of the
That's how
proviso
your
are not
lordships have
satisfied,
interpreted-
clause 3 will not
That's how
apply.
your lordships have interpreted proviso since 1950, Malas. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a
or-
difference, Malas. Yes.
It depends upon the nature of the.
Provisos are sometimes change
That's
colors.
proviso, Malas. Proviso that the recommendation,
Rule for a proviso in that sense.
provided that the recommendation of the Constituent Assembly shall be necessary. It's a restriction on the exercise of power. That's right. Referred to in clause 2, Malas.
Quick way to interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state is no longer exists.
But you kindly read 2, Malas. If the concurrence of the government of the state referred to in para 2, subclause B of 1 or the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause and clause D not applicable to clause C.
No,
Then
what
the
I'm
second
saying is,
proviso will not
in
apply.
both cases,
And therefore, only subclause 3 will apply.
Malas, point is clause 2 says that
clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of argument.
No, there is something that's missing, Malas. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malas? The purpose is given in clause 2. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say that it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
Right?
why it was.
That's your point. You get that point?
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body, the Supreme Court is a permanent
No
body.
doubt about it.
It's a body which has a specific purpose, and thereafter it becomes functus officio,
Right.
so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is, then you are applying 3 without the proviso and saying this is a blanket power, then then Malaj, the president can do it anytime without any consultation.
Also, Mr. Sibal, one thing which we must bear in
passes an
mind-
order
Mr.
that I
Sibal,
integrate. That's
One
surely,
thing which
surely.
we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary
Sure, sure.
for a limited period of time,
Right.
but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
That it comes to an-
Laws
Right.
made earlier.
I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yeah.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372,
Right.
which continuance in force of
Existing laws.
existing laws,
Yes.
which then says, shall continue in force until altered or repealed or amended by a competent legislature
Right.
or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may, by order made before the 1st of November 1957, make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of part 21. And 370 specifically uses the expression temporary.
It had to, Malaj. It had to.
So, can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the Constitution?
But that's one, your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malaj. There was nothing there at that point in time. It had to be, Malaj. It could never be a permanent thing.
So why did the Constitution then put it in part 21?
Because, Malaj, it is it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, part 21 does not deal only with Kashmir. Doesn't deal only with Jammu and Kashmir. It deals with other states.
I'm sorry, I didn't get.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it's a separate independent provision and has to be interpreted on its own terms. You can't incorporate Muller's concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
General note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Mullah. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else.